never thought necessarily, that part-time gig would extend into 19 years. But after I got out of college, I was lucky enough to get a management position in customer service at the call center in Sacramento. And then after that, had an opportunity to work in regional operations for the Western region ground operations, which was at the time headquartered in Sacramento. So that was the 13 Western states. Anything being trucked or delivered in those 13 states rolled up to that region, and then had the opportunity to actually come on board as a senior manager in Sacramento for ground operations. That's pretty much Northern California for those on in the audience who know, from say Sacramento up towards Reno, and then also supported the air operations out at the international airport at the time. FedEx was loading and unloading 727 aircraft at that time with the packages coming in and out. So a little bit of everything, a little bit on the ground side, a little bit on the air side. And then in 1989, I was actually brought on board to start up the government affairs function for FedEx in the Western U.S. So again, from Colorado westward, anything that had to do with state legislation or local ordinances and legislation, I would get involved with. Again, both for the ground ops for FedEx and the air ops.
Well, Sean, what's so valuable there with your background right out of college is you saw how invaluable a professional driver is, someone working in transportation. You saw the hard work that they put in, long hours. And so that really helped segue many, many years later your role as CEO of the California Trucking Association, advocating for truckers, the largest state association in the country. And what we want to really focus on today, since there's so many independent contractors in our audience, is California Assembly Bill 5, effectively known as AB5, and how that has impacted. It went into effect, I believe, January 1st, just a little less than a month ago, January 1st, 2020, and how it impacts independent contractors, all independent contractors that work in California, but most importantly, independent contractors in trucking. So can you share a little bit about the background of AB5 and how it's impacting fleets and independent contractors in California?
No, I'd be happy to do that. And John, as you mentioned, in terms of the background, I got to rewind this back even a little bit prior to AB5 itself. So where this all really began was in the spring of 2018. There had been a case going through the court system in California involving a small package delivery company called Dynamics. And at one point there in 2018, it was before the California Supreme Court, and that case involved whether the small package delivery drivers for Dynamics were being misclassified. They were running a business model of independent contractors at the time. And when the Supreme Court came to rule on that particular case, what they did, in addition to simply ruling on the case before them, the Dynamics situation, and ruling on the classification question, the Supreme Court actually did what I call, they legislated from the bench. They not only ruled on that case, they overreached and overextended and actually created this ABC test, as they call it, for determining in California who should be classified as an employee and who could be classified as an independent contractor.
Sean, could you explain a little bit about what the ABC test involves?
Sure. And without going into great detail, you have to, in order to be considered independent, you have to clear each of those components, the A, the B, and the C. And A has to do with the level of control that the contracting entity has over the contractor. And so the B prong itself is the one that really is the focus for everybody, because in the B prong, it basically says, if you are in the same or similar line of business, meaning you, the contractor, being in the similar or same type of business as the entity you're contracting with, if those things are similar or the same, under the ABC test, you cannot be considered independent. So if you think about that very quickly as it applies to trucking, think about who independent owner-operators are typically contracting with, right? They're contracting with motor carriers. And you would say that both of those entities are in the same or similar line of business. So right there, the B prong is impossible to clear as it relates to the trucking industry. So when I say ABC test, yeah, there are those three prongs, but the one that ends up being devastating is that definition of the B prong. It's something it's a hurdle you cannot clear as it relates to trucking. So the Supreme Court ruled on that. On that case in the spring, they created the ABC test. So at that moment in time, that ABC test became the law of the land in California. What we did as the California Trucking Association that fall, a few months later, we filed suit against the state of California, and we challenged that Supreme Court ruling because of that ABC test. And our claim at that time was that ABC test violated or flew in the face of federal preemption. And if it's okay, John, I can walk everybody very quickly why trucking has federal preemption over these types of state laws or these types of court rulings, if that's okay.
Yes, certainly. There's some of our listeners are fleet executives, attorneys in the profession, so I think it's very, very important. Thank you.
Sure. So in 1994, the Congress enacted the Federal Aviation Administration Authorization Act, known as the F4A. And when they did that in 1994, that piece of legislation covered a variety of topics. But one topic it covered specific to trucking was it basically said in the case of the movement of goods in an interstate fashion, that there needed to be federal uniformity, that the Congress did not want to see a patchwork of 50 different state laws and rules and regulations that would disrupt the flow of commerce. So as they said in that federal law, states cannot pass laws or regulations that would significantly disrupt rates, routes, or services. So if you think about those three terms, and they meant those terms to be very broad, rates, routes, and services, that covers a full gamut of areas of trucking, as you can imagine. So in the case of this new ABC test or this new independent contractor test, it was clear that if you're basically going to deny the ability for someone to operate independently, deny an owner-operator the ability to haul for a motor carrier because they can't clear that B prong, you have effectively interfered with interstate commerce or the movement of goods. So we based our lawsuit, the first of it being in the fall of 18, on that question of federal preemption, meaning that ABC test, is preempted. So we filed that suit, but as you got into 2019, you had the California state legislature who basically said to themselves, okay, we have this Supreme Court decision. We want to codify that. We want to go ahead and firm that up into state law. But what they did as well, the Supreme Court decision didn't cover every part of labor law. It covered one particular component of it. So the legislature created and crafted AB5, and they broadened that to mean in any case that ABC test, if you're in violation of it, it affects every part of labor law. And without going into the details again, it just basically devastated the ability, not just trucking, and we can get into some of the other industries as well. It basically, flipped the owner-operator or the independent contractor model on its head. And that legislation went through, was passed last fall, was signed by the governor. And what we did in our court case was we were able to go back to the court. The federal court is where we filed our original lawsuit. We were allowed to amend our lawsuit because once AB5 was signed into law, it made it, even more troubling. So we were able to amend our complaint, refile it in November, and again, claim that AB5 is preempted by federal law for trucking. We're probably the only industry that has any kind of strong federal preemption argument over AB5. Other industries are certainly trying to do their legal challenges on other grounds, but we knew we had a very strong position because of that federal preemption, because of that law from 1994 in Congress. So as we got closer to the end of the calendar year, and we knew, as you said, John, that AB5 took effect on January 1st, we asked the court for a preliminary injunction to stop the state from enforcing it. As we got closer to January 1st, we realized we weren't going to be able to get in front of the judge quick enough based on the calendar, so we filed for what's called a temporary restraining order, or a TRO. We were very happy when the judge granted our TRO on December 31st.
Wow.
So the day before AB5 took effect, we were able to get a temporary restraining order. So that was great news for trucking. And then as we moved on, that TRO was only in effect for technically 14 days. So the judge did hear from our side, and they heard from the opponents of ours on January 13th. And we had 2 hours of oral argument for us, again, trying to convince the judge to give us the preliminary injunction to keep the state from enforcing AB5. We were happy 3 days later when the judge actually granted the preliminary injunction. So that is in effect right now. We've got the state, stopped from enforcing AB5, which is great news for the industry and for the owner operators out there. And until such time as the judge eventually rules on our case overall, there's that suspension of the state enforcing. So that's great news in terms of where we're at right now.
Well, Sean, sounded like you and the staff were very busy working around Christmas and the holidays, getting that in temporary restraining order on December 31st. Doesn't sound like you had a whole lot of time off there at the first of the year.
Well, I got to tell you, I got to tip my hat to the attorneys and the law firms that CTA brought on board to carry this particular lawsuit and represent us in the courts. We really a top-notch team. We're also blessed in that our CTA members are funding the lawsuit. As you can imagine, it takes a lot of money to see a lawsuit like this through. So we have CTA members and others in the industry, whether you're in California or outside of California, who are, contributing and helping with that fight, because even though we spent a great deal of money so far to see this thing through, right, as you can imagine, it's going to go up through an appeal process. It could eventually get to the U.S. Supreme Court. So it's vital for this fight that we continue to be able to fund it. So we've been very fortunate that people have stepped up to the plate and have helped us in this regard. But yes, it was definitely active during that holiday stretch. And again, to get that great news on December 31st was, again, wonderful for the industry.
Sean, do the independent contractors that are leased on to trucking companies based in California, is there anything they need to be doing on the interim, or is it just business as usual?
Well, I think that's a good question. I think that varies based on the motor carriers, because the motor carriers are the ones that have had to make decisions as we got closer to January 1st. If I'm XYZ motor carrier, I had to make a decision as we were approaching January 1st. What are we going to do? I know of some situations, and again, none of anything I'm talking about is in any kind of legal advice. We don't give legal advice from the CTA. We always recommend anybody who has technical questions about AB5 should, definitely seek legal counsel. But in the case of a motor carrier, we've heard the full spectrum of reactions as it came to January 1st. You had some motor carriers who were reaching out to their owner operators and saying, look, you either got to come on board as an employee, or possibly you need to relocate out of the state of California, so you're not a California resident, that wants to be an independent contractor. We've had some motor carriers who have said, look, I really believe in this federal preemption, and we know that there's a court challenge on this, so we're going to see how the dust settles on the legal challenge. So just a lot of confusion, and I would say for the owner operators, it's been devastating. One thing I'd like to touch on is, as AB5 was going through the state legislature throughout the year, last year in 2019, even though all of these other industries were also impacted by AB5, and think about the gig economy, Uber, Lyft, DoorDash, Postmates, the gig economy. You had hairstylists, you had emergency room doctors. I mean, think about anybody who participates as owner operators, the freelance writers for publications.
Yeah, just think of Hollywood.
I mean, you name it.
Yeah.
Yeah, a big part of Hollywood, absolutely.